Well, we have another motion in the Wallace v LVMPD et al. It's plaintiff's motion to extend time to respond to motion. That sounds pretty boring, but within it, there's some goodies. So, introduction. I, Plaintiff Floyd Wallace, pursuant to Federal Rule Civil Procedure Rule 6, moves this Honourable Court for an extension of time to respond to defendants Las Vegas Metropolitan Police Department's motion to strike plaintiff's complaint at ECF number 10. This motion is made and based on the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of the hearing. I have notified defendants of my intent to file for sanctions under Federal Rule of Civil Procedure, Rule 11, because their motion lacks any factual or legal basis and is only meant to delay and harass. Defendants were notified on July 18, 2023 and have until August 8, 2023 to withdraw their motion under the safe harbour provisions of Rule 11. Plaintiff requests until August 15, 2023 to respond to defendants' frivolous motion. Memorandum of Points and Authorities. A. LVMPD has no factual basis for their claims. In LVMPD's motion, no factual assertions are supported by a declaration or affidavit, and the attached document has no verification. Pursuant to Federal Rule of Civil Procedure, Rule 75(d), the motion is not supported and cannot be corrected by a reply because a supporting declaration must be served with the motion. Even if LVMPD's attorney had included a declaration of his statements, it appears that he lacks personal knowledge of at least one of the facts. Further, LVMPD's statements include hearsay from non-parties and statements that in general are irrelevant to this case. LVMPD's reasonable inquiry into the evidence as required by Federal Rule of Civil Procedure Rule 11 would have simply revealed that one complaint was referenced material for the other. LVMPD fails to include evidence of the illegal practice of law in the filing of my complaint. LVMPD fails to say that there would be evidence of the illegal practice of law in the filing of my complaint should they have the opportunity for further investigation. Instead of requesting relief for plagiarism, LVMPD requested unrelated relief without any supporting evidence related to the illegal practice of law during the filing of my complaint. Further, LVMPD offers no evidence that Jose de Castro is not a licensed attorney in whatever state statutes they are claiming were violated. Brackets, no state statutes were cited. B. This court may issue sanctions on LVMPD, their attorneys, and anyone that files or submits the paper. LVMPD's frivolous motion completely lacks any factual or legal basis and is clearly only meant to delay the need for a responsive filing while LVMPD's frivolous motion is pending, as indicated in LVMPD's reference to Carter v. Penzone and to harass De Castro or his associates. Why is there so much De Castro in here, I wonder? Is it because De Castro assisted in the writing of this motion for further time? Anyway, continuing. The costs imposed by LVMPD's motion on me and on the judicial system could have been avoided by a reasonable free-filing inquiry. A reasonable attorney would not have found this motion's request for relief to be well-founded based on the evidence, or lack thereof, in this motion. A lawyer must distinguish a fact from an inference he seeks to press on the court. It is unprofessional conduct to represent inference as facts, and there's some references there. And I'll start with authorises this court to order sanctions on its own to deter future frivolous motions. C. Rule 6 authorities. This court to extend time. Federal Rule of Civil Procedure Rule 6 (1) B grants this court the authority for good cause to extend the time before the original time or its extension expires. Courts in this circuit have allowed extensions of time while safe harbour periods are run down. And there's further references. Here, plaintiff has shown good cause related to a safe harbour period for a valid Rule 11 sanctions motion. Conclusion. Accordingly, plaintiff respectfully requests this court 1. Extend the time to file a response to defendant's motion until August 15, 2023 to allow for defendants to withdraw their frivolous motion. Is that De Castro not wanting to work on a response to the frivolous motion that accuses him of the illegal practice of law? Thanks for watching.